Hello students, good evening all. Welcome back to the daily news analysis. I trust you all are doing great. Well students, our intention behind the daily news analysis series is to make you understand the nitty-gritties of the current affairs, because here we give the exhaustive analysis, in-depth analysis of the daily current affairs, right? And when you are listening something, when you are watching something, when you are listening, when you are seeing something, it tends to get into your memory, right? You are better able to absorb those things when you are listening and seeing something, right? Because here all your senses are working, right? So therefore this series is intended to make you aware about the current events, to give you the in-depth analysis of the things surrounding you, right? With your educator Prithviraj Singh, the daily news analysis for 6th of May 2022. Right now, on the front page of the Hindu, there was an article about sedition, right? You all would be knowing about sedition, guys. Sedition is any act of contempt or any act which results into contempt or hatred or disaffection against the government, right? Basically, the law was being formed by the Britishers in the in the 19th century. There was a British officer named Thomas Babington Macaulay, and Macaulay actually came up with this act called as Sedition Act, because there were various writings in the press by the freedom fighters. They were writing some inflammatory editorials. They were giving inflammatory speeches to incite the people for violence against the government. It was actually resulting into hatred and violence against the government, right? So a British colonial law, and then it was being later included into the Indian Penal Code, the criminal provision of India, the IPC 1860, in section, you all know that it is section 124A of IPC, which talks about sedition, right? So as I said, that any act which brings into the hatred or malice or contempt or disaffection against the government is called as sedition. And because its objective was to curb or suppress the anti-government activities during the freedom struggle, right? So many freedom fighters like Gandhi, Bal Gangadhar Tilak, and Aurobindo Ghosh, their writings were being suppressed. They were all being charged under the sedition law, right? Because it was being felt by the British government that it is inciting hatred and violence against the government, right? So the British government was afraid of such speeches or such writings, and therefore they started curbing or suppressing such things, right, under the sedition law. Correct. Now sedition, its intention is good, because anything if it's going against the national integrity, security or public order, or which in turn would result disaffection against the government, is definitely not good, right? And but at the same time, how if the government is misusing or abusing the sedition law? Is it the case that if we cannot express our dissent against the government? Because as a citizen of the country, every person should be critical of the government, right? And there is nothing called as perfection. No person or no government for that matter can be perfect, right? So does it mean that when you have section 124A, you cannot express your dissent against the government? You cannot speak against anything against the government, right? Because it has been seen in many cases where people tried speaking against the government and they were booked under sedition law. They wrote something against the government, again charged in the section 124 IPC. Even many cartoonists like Asim Trivedi, you would be knowing, quite a few years back, he drew a cartoon, a caricature, where a person was standing in front of the parliament and urinating on the parliament, right? And then this was being booked under sedition law, He was being charged under sedition law, right? Now, in this sense, definitely that was too outrageous. But then the question is that where you will strike a balance between what is sedition and what is misused by the government, because government may misuse the sedition law, and any person who says anything against the government, and possibly it is something because it is the right of every person to critically analyze the policy of the government. But if you say anything against the government, you have always that bandwagon of sedition, right? So therefore sedition cases are there coming into the courts. And in 1962 Supreme Court, in Kedarnath versus State of Bihar, 1962, the Supreme Court upheld the sedition law, right? Upheld the sedition law and upheld section 124A of IPC. But at the same time the court said that the sedition law would be used only when the activities involve incitement to violence or intention or tendency to create public disorder or cause disturbance of public peace. That means you can charge a person under sedition law only when his or her activities is involving any incitement against the government or any incitement to violence, right? So when there is an element of violence in his speech or in his writing, or intention or tendency to create public disorder, that means if his speech results into public disorder or would cause a public disturbance, or disturbance to the public peace, right, then only the government may use the sedition charges under section 124A IPC, right? So I repeat again, only when your speeches or writings are inciting violence in the public, among the public, or it is against the public order, or it disturbs the public peace. So in this way, Kedarnath versus State of Bihar judgment of 1962 limited the use of the sedition law to the extent that it can be used only when against any speech or any writing which incites into violence or which disturbs the public order or disturbs the public peace, right? At the same time, it upheld the constitutional validity of section 124A IPC, right? I hope it is clear. Now, there are many lawyers who have their own opinion about the sedition law. The Attorney General of India, K.K. Venugopal, the highest law officer, the first law officer of the country, he says that the Kedarnath judgment is the last word on the issue of sedition law. It has balanced well the right of security of the state and the right of free speech, because we all know that we do have the freedom of speech and expression. Can you tell me which article is freedom of speech and expression? Please give your answers in the comment box. Which article is right to freedom of speech and expression? It is Article 19, Clause 1, Subclause A, right? There are 6 fundamental rights. There are 6 rights under Article 19, which is right to freedom. So the first right, that is Article 19, Clause 1, Subclause A, talks about the freedom of speech and expression, right? So K.K. Venugopal, the Attorney General of the country, says that the Kedarnath judgment has balanced well the right of security of the state and the right of freedom of speech and expression, right? Whereas Kapil Sibal, the senior counsel, says that section 124A is per se unconstitutional. It cannot be used to silence dissent and take away personal liberty. So he is more concerned about the negative side when the government misuses or abuses the sedition law, when a person cannot express his dissent against the government, and in this way it actually takes away the personal liberty, right? Now the issue is that Supreme Court whether it can study if the larger bench should hear the sedition pleas, because the Kedarnath versus State of Bihar, the case came with 5-judge bench. It was a constitution bench of 5 judges, right? Now it can be reversed only with a larger bench greater than 5. That means if it is 7 or 9, so on and so forth, right? Now the case says that the Supreme Court will to study if larger bench, larger than the 5 Kedarnath judge bench, should hear the sedition pleas, right? Now whether sedition should continue or be struck down in the light of subsequent development in law post Kedarnath judgment and global opinion on sedition, because guys, although the British officer Thomas Macaulay did introduce sedition in 19th century, but even in UK it has been discontinued. In UK since 2010 sedition law has been discontinued, right? So there is a growing global opinion in the world against the sedition law, right? So therefore, is it the right time, or has the time come to actually deliberate over removing or reforming the sedition law, right? So the continued article says that the misuse of sedition law should be controlled, because there has been many cases where the government has misused or misused the sedition law, and this court can lay down certain guidelines in the implementation of the law, right? So at least the court can lay down certain guidelines which would check any misuse or abuse of the sedition law. Now Article 19 Clause 1 Subclause A of the Constitution, now in this it had not examined how sedition could be misused by the government to cripple the right to life and dignity and right to equal treatment under Article 21 and 14 respectively, right? So this is the case, and a very important article, and there are many important takeaways from this. Number 1, what is sedition, who introduced it, right? Which section in our IPC talks about sedition? Section 124A. Then what is Kedarnath versus State of Bihar 1962 judgment, the only judgment till date on sedition, I mean the landmark case, and how Kedarnath is balancing the right of security of the state and the right of freedom of speech and expression, right? So important article. So it is all about the same. I've actually explained it in detail here, right? So section 124A clearly says that any activity involving incitement to violence or intention or tendency to create public disorder or disturbance of the public peace would be regarded as sedition, right? Now as I say that Thomas Macaulay in the year 1837 introduced the sedition law, and he clearly said that whosoever by words either spoken or written or by signs, that means even it includes signs, I mean it includes the verbal the spoken words, the written words, the written statements, the signs, by visible representation or otherwise brings or attempts to bring into hatred, contempt, or excites or attempts to excite disaffection towards the government established by law in India, right, would be booked under sedition law, right? Now as far as the punishment is concerned, you must understand that it is a non-bailable offence. That means the person who is booked under sedition charges do not have the right to bail. He cannot ask for bail, right? So it is a non-bailable offence. And as far as the punishment is concerned, the minimum punishment that it has is 3 years up to life, right? So this may also be asked in the examination. So it is 3 years up to life, along with a fine, plus fine, right? As I said that even UK has abolished the sedition law in the year 2010, right? Very important takeaways. Now even the Law Commission, which was set up in the year 2018, it came up with a report in 2018, and it also said the same thing, that people should be at liberty to show their affection towards their country in their own way. I mean, it is not that you sing the same national anthem from the same songbook and then you say you believe that you are patriot, right? Because people should have the liberty to show their affection towards their country in their own way, right? And for doing the same, one might indulge in constructive criticism or debates, right? Because when you are showing respect or when you are showing their affection towards the country, that means you are critical of the government, right? And an aware citizenry is always critical of the government. There are pros and cons of every policy, and an aware citizenry, an informed citizen, is always critical about the government, right? So democracy is one where there is scope and space for constructive criticism, constructive debates, pointing out the loopholes in the policy of the government, right? And this is how our democracy flourishes, right? If you curb this, if you suppress the dissent, then one day the pressure cooker would burst, right? So therefore, sedition law in this sense was also being objected by the report of Law Commission 2018, and this report in fact opined that sedition law can be invoked only in cases where the intention behind any act is to disrupt the public order or to overthrow the government with violence and illegal means, right? Either you are overthrowing the government, I mean the intention is behind your speech or your writing is to overthrow the government with violence and illegal means, then only one can be booked under the sedition law, right? So this is there, and it should be scrutinized whether the word sedition could be substituted suitably with another. So this is also was being proposed by the Law Commission report 2018, right? So I hope it is clear. A very important article, and you all must read it thoroughly, and my explanation would definitely help you out, because here I have mentioned a background about the sedition law, Thomas Babington Macaulay, and those things are not mentioned in the article, right? Now there has been many cases, guys, sedition cases in our country. Disha Ravi was also being booked recently when she shared a toolkit for a global online campaign supporting the farmers' protest post the contentious 3 agriculture farm laws, right? Even student activists like Umar Khalid, Sharjil Imam, Devangana Kalita, etc. were being booked under section 124A IPC when they were protesting against the Citizenship Amendment Act. Similarly, Siddiqui Kapan was also being booked when she was to proceed towards Hathras, where 19-year-old Dalit woman was gang raped. Similarly, activist Sudha Bhardwaj, Vernon Gonsalves were also being booked for their speeches at Elgar Parishad, right? So on and so forth, right? In this way, it has to be looked upon, and as I said that it is a cognizable offence. In this way, it means that the investigation process, including the powers to arrest, can be triggered merely by filing an FIR, right? Without a judicial authority having to take cognizance, correct? So that means it is a cognizable offence, plus it is also non-bailable. As I explained that in non-bailable offences, the accused cannot get bail as a matter of right, but it is subject to the discretion of the judge of the court, right? So it is non-bailable and it is cognizable, right? Now I hope it is clear. Moving to the next news article. Even the international organizations have come up with the freedom of speech and expression. They have come up, especially the International Covenant on Civil and Political Rights, ICCPR, also said that everyone should have the right to hold opinion without interference. Every person should have the right to hold opinions, right? They also talked about the right, which include the freedom to seek, receive and impart information, so on and so forth. So International Covenant on Civil and Political Rights in 1979 also talks about the, also have, you know, discussed about the Article 19, and similarly so on and so forth, right? So I hope it is clear. Moving to the next news article on the screen about Naga peace talks. The status of Naga peace talks, a long pending dispute where the people in Nagaland, the tribals in Nagaland, want a separate, isolated state outside India, an independent country in itself called as Greater Nagaland or Nagalim, and this geographical entity would have some of the areas from the neighboring Assam, etc., right? Manipur, Assam, etc. So this issue is a very long pending issue, and many violence and violent activities have taken place because they are still demanding a separate state of Greater Nagaland or Nagalim, right? Now, the recently released annual report of Ministry of Home Affairs said that Isaac Moiva faction of the NSCN-IM or National Socialist Council of Nagaland, Isaac Moiva faction was involved in 44% of insurgency related incidents in Nagaland, right? इसका मतलब नागालैंड के अंदर जो इंसर्जेंसी हो रही है, राइट, उसमें 44% केसेस के अंदर तो NSCN-IM ही इन्वॉल्व है, राइट? तो NSCN-IM जो है नेशनल सोशलिस्ट काउंसिल ऑफ नागालैंड, जो आइसक मुइवा फैक्शन है, इट इज इन्वॉल्व इन 44% ऑफ इंसर्जेंसी रिलेटेड incidents in Nagaland in 2020, right? Now, so in this sense, in this backdrop, we would be understanding the Naga peace talks. Guys, the union government did signed in the year 2015 a framework agreement with NSCN-IM to find a solution to Naga political issue, but the negotiations are yet to be concluded, right? They are still demanding a separate state for the tribal, the Nagas, which they call Greater Nagaland or Nagalim. Right. Now, why did the Naga insurgency begin? On the very first point, right? Now, guys, Naga was created by the British for administrative convenience, right? The term Naga was being used for the first time by Britishers for administrative convenience, right? And the Britishers had a very different way of administering or governing the Naga tribes, right? And it was different from the Assam province, because you may be knowing that Assam was also one of the British governor's province, but then there were many Naga tribal people living there, you know, and Britishers found altogether a different way of governing and administering the Naga tribes, right? Because the Naga tribes have, you know, although they have similar origin, but distinct culture, dialect and customs, right? Now the Naga tribes are accumulated not only in Nagaland, but they are spread across some parts in Arunachal Pradesh, Manipur and Myanmar, right? Now they were, you know, residing in the hills of Assam when the Britishers came to India and and post the annexation of Assam in the year 1820. Nagas did never consider themselves as part of British India, right? Because they were tribal people, and although the Britishers annexed Assam in the year 1820, but Nagas, as they were the indigenous people, they were the forest dwellers, they never considered themselves as a part of British India, right? Therefore, Britishers had to adopt a different way of governance and administration of Naga tribes, right? That involved, you know, keeping in place their traditional ways of life. So Britishers ने एक technique, they devised a new technique to administer and govern the Naga tribes, wherein they would be preserving and conserving their traditional culture, customs and laws while putting the British administrators at the top, right? In this way, their customs, traditions, culture was protected, was preserved while the Britishers were actually governing them, right? So Nagas were very confident of this kind of administrative structure as being proposed or being operated by the British authorities. But when India got independence, they become hesitant of the structure that would be there applicable on them post India's independence, right? So there was uncertainty about the future of their cultural autonomy after India's independence, right? तो इंडिया के इंडिपेंडेंस के बाद कैसा सिस्टम होगा, उनको कौन गवर्न करेगा, क्या उनके कल्चरल राइट्स, ट्रेडिशनल राइट्स, कस्टम्स, रिचुअल्स वो प्रोटेक्ट होंगे, या कॉन्स्टिट्यूशन जो है सुप्रीम लॉ ऑफ द लैंड दैट वुड बी एप्लीकेबल देयर, राइट? सो देयर वाज so much of confusion, right? And that is the reason why all the insurgency, violence, separatism started among them, right? Now they established in the year 1945 the Naga Hills District Tribal Council, very important, NHDTC, correct, for them, which was later renamed as Naga National Council, NNC, in the year 1946. I hope you are comfortable till this. Now, amid uncertainties that what would be their position after independence in India, a section of NNC, that is Naga National Council, led by Naga leader A.Z. Fizo, very prominent and famous Naga leader A.Z. Fizo, बहुत नाम आता है इनका. He declared the independence of Nagas on 14th August 1947. मतलब a day before India got independent, they declared their independence from the country as a separate geographical territory outside the country, right? And post this, a underground insurgency began as early as 1950s, where Mr. Fizo, founded a party called as Naga Federal Government, NFG, right? The same Fizo which actually declared the independence to Nagaland on 14th August 1947 founded a party called as Naga Federal Government, and it had its armed wing called as Naga Federal Army, right? So Naga Federal Army उनकी armed wing थी, and Naga Federal Government was the name of the party, right? और जैसे ही ये चीज़ हुई, इंसर्जेंसी बढ़ी वहाँ पे असम हिल्स के अंदर, तो गवर्नमेंट ने 1958 के अंदर अफस्पा तो आ ही गया था. इट वॉज इनेक्टेड बाय द पार्लियामेंट, एंड द पार्लियामेंट, द सेंट्रल गवर्नमेंट एक्चुअली अप्लाइड और इम्पोज्ड अफस्पा, आर्म्ड फोर्सेस स्पेशल पावर्स एक्ट 1958 in the hilly regions of Assam to curb such insurgencies in the Naga areas. और आपको पूरी डिटेल्स बताई है अफस्पा की, हमने we have discussed it in our previous DNA sessions where the army gets extraordinary powers, right? Now the Nagas, which were led by Mr. Fizo, started demanding an independent state outside India, right? Completely sovereign. Now and this actually, unlike other groups in the northeast which were accepting some form of autonomy, right? Because slowly and steadily many states were being crafted out, new states were being crafted out, or union territories were being crafted out from Assam, and they were accepting some form of autonomy under the constitution, but Nagas rejected in favor of sovereignty. They wanted their independent state, right? And then some leaders among the NNC, right, some leaders in the NNC, Naga National Council, formed their own group to hold the discussions with the government, leading to the formation of the state of Nagaland in the year 1963, right? So there are some group members in NNC which actually, led to the formation of the state of Nagaland, right? However, this idea was not, being accepted by all the members of the NNC, right? And many people in NNC and NFG were not satisfied, and following years of negotiations with the government, they eventually signed something called as Shillong Accord in the year 1975, right? तो ये सारे developments and events बहुत important है when you have to understand the Naga Peace Accord. Shillong Accord of 1975, agreeing to surrender the arms and accept the constitution. तो Shillong Accord 1975 में they accepted to surrender the arms and accept the supreme law of the land, that is the Constitution of India. अब बात आई कि शिलोंग अकॉर्ड के बाद, नाउ द शिलोंग अकॉर्ड was not agreeable to the top leadership of NNC, right, and those operating from Myanmar, as the agreement did not address the issue of Naga sovereignty and coerced them to accept the constitution. That means they were being forced to accept the constitution, right? So constitution was being imposed or dumped on them without actually addressing the issue of Naga sovereignty, right? नाउ इन्हीं एनएनसी के अंदर जो कुछ टॉप 3 लीडर्स थे, उन्होंने एक नई ऑर्गेनाइजेशन बनाई जिसको कहते हैं NSCN, दैट इज नेशनल सोशलिस्ट काउंसिल ऑफ नागालैंड, टू कंटिन्यू द आर्म्ड मूवमेंट. एंड द मोटो ऑफ NSCN was to create a People's Republic of Nagaland, completely sovereign and free from the Indian rule, right? NSCN, National Socialist Council of Nagaland. Now 1988 के अंदर, after years of infighting and violent clashes along the tribal lines, NSCN got split into 2 factions. 2 factions में split हो गया NSCN. The first was NSCN-IM, which was actually led by NSCN Muiwa. Muiwa was the leader there, Muiwa and Shru, right? And NSCN-K, right, which was led by Mr. Khaplang, right? So there were 2 factions, NSCN-IM and NSCN-K. Now NSCN-IM demanded, and still it continues to demand, a greater Nagaland, a separate country, right, sovereign country, or Nagalim, and it wants to extend Nagaland's border by including Naga dominated areas in the neighboring states of Assam. मतलब असम, मणिपुर और अरुणाचल के भी कुछ एरियाज को वो इंक्लूड करके ग्रेटर नागालैंड करके एक सॉवरेन कंट्री बनाना चाहते हैं, राइट? आई एम टॉकिंग अबाउट द NSCN-IM मोइवा सेक्शन, राइट? नाउ NSCN-IM in 1997 signed an agreement or ceasefire agreement with the government to begin the holding of talks with the aim of signing a Naga peace accord. तो इस तरीके से more than 100 round of talks took place over 24 years, but the solution is still awaited. There is still high insurgency, violence, armed rebellion, right? And in 2015, a few years back, the government signed framework agreement with NSCN-IM, right? The first step towards an actual peace accord, the framework agreement with the NSCN-IM. इसके अंदर जो जॉइंट इंटेलिजेंस चीफ थे RN Ravi was being appointed as the interlocutor for the Naga peace accords, right, on behalf of the center, and he was later appointed as Nagaland's governor in the year 2019, right? अब यहाँ पे negotiations तो हुई, बट सोल्यूशन कोई अराइव नहीं हो पाया, और NSCN-IM is still demanding their separate state of Greater Nagaland, and even they are demanding the removal of Mr. Ravi, who is now the governor of Nagaland, as interlocutor, accusing him of high-handedness and tweaking the agreement to mislead other Naga groups, right? So in this sense, the NSCN-IM continues to demand a separate flag, separate constitutional status for Nagas, and the creation of Nagalim or Greater Nagaland, right? So I hope this issue is clear, right? So in this way, coming to the first slide of this article, that the recently released annual report of Ministry of Home Affairs says that the NSCN-IM, जो हमने बात करी थी, जो सेक्शन नया बन के निकला था NSCN का, which is Isaac Muiwa's faction, right, is involved in 44% of insurgency related incidents in Nagaland in the year 2020, right? So the government has to arrive at some solution, and before it gets, it spirals up or escalates. I hope it is clear, and it's very important news article. Moving to again the front page of the Hindu, where the article was on the Delimitation Commission report, which is now being published, right? And it is in the final stage of the Jammu and Kashmir, the Delimitation Commission report of the Union Territory of Jammu and Kashmir. Well, students, you all would be knowing that Jammu and Kashmir did had the special status, as you all know, under Article 370. But post the Jammu Kashmir Reorganization Act, post the Jammu and Kashmir Reorganization Act of 2019, its special status was abrogated and the state was reorganized. State was reorganized into Union Territory of Jammu and Kashmir with State Legislative Assembly and Union Territory of Ladakh without any State Legislative Assembly. So in Jammu and Kashmir, the state of Jammu Kashmir was being bifurcated into Union Territory of Jammu Kashmir with Vidhan Sabha or with State Legislative Assembly and Union Territory of Ladakh, right? Now as far as the seats are concerned, if I talk about the State Legislative Assembly of State of Jammu and Kashmir, there were 83 MLAs. As far as the Delimitation Commission, which actually demarcates the boundaries of the electoral boundaries of the state and the Union Territory with State Assembly, it has considered 2011 census. And can you tell me who is the chairperson of the Delimitation Commission for Jammu and Kashmir? Drop your answer in the comment box. Is Ranjana Prakash Desai, retired Justice Ranjana Prakash Desai, right? Now the State Legislative Assembly of the state of Jammu Kashmir had 83 MLAs. Now this has been increased by 7, right? And now there would be 90 MLAs in the newly created Vidhan Sabha of Union Territory of Jammu and Kashmir, right? So from 83, now there are 90 MLAs, correct? That means there is an addition of 7 MLAs in the Vidhan Sabha of the Union Territory of Jammu Kashmir. Now if I bifurcate into the Jammu province, I mean the Jammu region and the Kashmir region, I will get that 6 seats have been increased in the Jammu region, whereas 1 seat has been increased in the Kashmir region, right? Very important takeaway, and there is strong probability of it being asked in the examination, right? So guys, 7 seats बढ़ा दी गई है विधान सभा of Union Territory of Jammu Kashmir में. Earlier there were 83 seats and now there would be 90 MLAs, right? Now here I am saying excluding POK and the seats for Ladakh. So I have excluded the seats for POK and Ladakh, right? I am strictly restricting myself to Jammu and Kashmir, excluding POK and Ladakh, right? Because that is a different figure, right? अगर मैं इनको include कर देता हूँ तो उस समय there were 111 seats, 111 MLAs, right? और अभी जो है वो 114 seats हो गई है. If I include all the POK, Ladakh and the Union Territory of Jammu and Kashmir, right? But here we are concerned more about the Jammu and Kashmir, excluding POK and Ladakh, because Ladakh is already now a separate Union Territory, right? So from 83 to 90, right? Plus very important development, guys, which has been for the first time in the history of Jammu and Kashmir. For the first time, 9 seats have been allocated to the scheduled tribe category people, right? So for the first time, 9 seats have been allocated, have been reserved for the first time 9 seats have been reserved for scheduled tribes, right? And in this way, for the first time, a tribal reservation for the state of Jammu Kashmir has actually finally happened, right? Because again, reservation of seats for SC and ST is mentioned under Article 332, right? Reservation of seats for SC, ST in Vidhan Sabhas or state legislative assemblies are clearly mentioned under Article 332. So the Vidhan Sabha of Jammu and Kashmir state was actually, violating Article 332 since the enactment of the Jammu Kashmir Constitution, right? So it is a very welcome move, right? So these are some important takeaways. Apart from that, if I talk about further bifurcation of these 9 seats, out of these 9, Jammu has 6 seats for the tribal and Kashmir has 3 seats, right? So 6 plus 3, 9, correct? And in this way, this bifurcation is being done. Now, as far as the Lok Sabha is concerned, and the Lok Sabha seats from the Union Territory of Jammu and Kashmir, there have been 5 seats across 18 state legislative assembly or Vidhan Sabha segments or constituencies, right? So there have been 8 seats, there have been 5 seats across, divided into 18 Vidhan Sabha constituencies, right? So when you multiply 18 into 5, you will arrive at 90, right? So 18 Vidhan Sabha segments are, are being there under 5 seats. So 5 seats have all the 18 Vidhan Sabha constituencies, right? So in this way, the Delimitation Commission chaired by Ranjana Prakash Desai has come up with its report, and a very important development, right? I hope it is clear, something which is very important and would be asked in the examination, right? Very, very important, guys. Now moving to our discussion, the same thing is being mentioned here, correct? And they have also combined some of the constituencies of Lok Sabha, like Anantnag region in the valley with Rajouri region, right? So on and so forth. And this move has already been criticized, correct? Now moving to the article from Indian Express, that what has changed. Again, the same thing have been mentioned, which I have just explained on the board, right? Because the assembly seats was, and this is as per 2011 census, right? Wherein you know that all other state assemblies have their seats reserved as per 2001 census, right? And as I said, that erstwhile Jammu Kashmir state had 111 seats, and now they have been increased to 114, right? तो हमने जो division किया था उसके अंदर अगर if we divide it further, you will get that 46 were in Kashmir, 37 were in Jammu, 4 in Ladakh, plus 24 seats were reserved for POK, right? The further bifurcation, and constituency boundaries are being redrawn only in Jammu Kashmir when delimitation for the rest of the country has been frozen till 2026. And many other factors have also been considered apart from the census population, like the the remoteness, the size, the closeness to the border, so on and so forth, right? And for the first time, the commission has also proposed and recommended the provision of at least 2 seats for the Kashmiri migrants. Yes, they are talking about the Kashmiri Pandits, right? So for the first time in the history of Jammu and Kashmir, there a recommendation has come for the provision of at least 2 seats for the community of Kashmiri migrants, that means the Kashmiri Pandits, in the Legislative Assembly of the Union Territory of Jammu and Kashmir. Plus there is also a recommendation to give representation in the Jammu Kashmir Legislative Assembly to the displaced person from the Pak occupied Kashmir. Okay, so this is also which are actually migrated to the Jammu after partition. Okay, तो ये बहुत वेलकम मूव है, इट्स अ वेरी गुड इनिशिएटिव. जब कश्मीरी पंडित्स को एटलीस्ट 2 सीट्स मिलेगी प्लस ड्यू रिप्रेजेंटेशन मिलेगा उन लोगों को जो POK छोड़ के आफ्टर पार्टीशन जम्मू के अंदर सेटल हो गए थे. सो इट्स अ वेरी गुड मूव, राइट. सो यू कैन रीड दिस आर्टिकल फ्रॉम इंडियन एक्सप्रेस ऑल्सो, एंड in this way, right. Moving to the next news article on the board. WHO has estimated 4.7 million COVID linked deaths in India. ठीक है, जहां गवर्नमेंट कह रही थी कि केवल 4 लाख लोग कोविड से मरे हैं, राइट. दिस वाज द ऑफिशियल डेटा ऑफ द गवर्नमेंट ऑफ इंडिया. In this COVID, the pandemic which started from 2020 till date, only 4 lakh people have died. WHO की जो फिगर्स आई है वो कहती है कि 4.7 मिलियन लोगों की डेथ हुई है, राइट. 4.7 मिलियन इज हाउ मच? 47 lakh. It is just 10 times of the official data of the government, right. But here they say it as a excess death, right. I'll explain you what is excess death. The figure is nearly 10 times the government's official count for 2021, right. ये फ्रंट पेज पे ये न्यूज़ आर्टिकल है. आप देखोगे इंडिया की सबसे ज़्यादा एक्सेस डेथ्स है एसोसिएटेड विद कोविड-19, 47 लाख, और ऑफिशियली रिपोर्टेड तो केवल 4,80,000 ही है, राइट. तो एक्सेस डेथ्स एज अ मल्टीपल ऑफ ऑफिशियल कोविड-19 डेथ्स इज 9.8, राइट. सो इंडिया इज एक्चुअली as at the top of the chart as far as the deaths are concerned. 47 lakh people have died. I'm talking about and the report talks about the excess deaths, right. Now, and in total 15 million people across the world have died. उसका 1/3 part तो इंडिया के अंदर ही है, right. It's a startling figure by the WHO. और WHO के जो डायरेक्टर जनरल है, right, टेड गेब्रेयेसस, वो इंडिया आए थे अहमदाबाद के अंदर. दे ही इनॉग्रेटेड द ट्रेडिशनल मेडिसिन सेंटर एंड प्राइम मिनिस्टर मोदी गेव हिम अ न्यू नेम, तुलसी भाई. बट देन द फिगर्स आर वेरी डिफरेंट फ्रॉम व्हाट वाज अ फ्रेंडली जेस्टर, राइट. हाउएवर इट इज अ स्टॉकिंग रियलिटी, बट देन इट इज समथिंग टू बी एक्चुअली एक्सप्लोर्ड अपॉन. हाउएवर द गवर्नमेंट इज कंटेस्टिंग द रिपोर्ट. वो कह रहे हैं कि ये जो मैथमेटिकल मॉडल जो फॉलो किया है WHO ने, वो it is questionable, और therefore the excess mortality projections बहुत high बता दिए हैं उन्होंने, right. Now the director general of WHO, as you all know, is Tedros Ghebreyesus. अब excess deaths क्या होती है? Let's understand. I'm explaining here. Let's say pandemic began, it started from 2020, 2021, and still it is going on. इससे पहले लेट्स से आई कंपेयर द डेथ्स ऑफ द ईयर 2019, नॉर्मल ईयर व्हेन देयर वाज नो पैंडेमिक, राइट. तो व्हेन आई कंपेयर द नंबर ऑफ डेथ्स इन अ नॉर्मल ईयर विद द डेथ्स हैपनिंग इन द पैंडेमिक ईयर, तो जो डिफरेंस निकल के आता है उसको कहा जाता है एक्सेस डेथ, राइट. तो नॉर्मल ईयर में लेट्स से कि 100 डेथ्स होती थी, आई एम जस्ट अज्यूमिंग इट. नॉर्मल ईयर में जब कोई ऐसा पेंडेमिक नहीं था, व्हेन देयर वर 100 डेथ्स. अभी अगर लेट्स से डेथ 1000 अगर हो रही है, राइट, तो क्लियरली पता पड़ रहा है कि ये 10 टाइम्स ज़्यादा डेथ हुई है, राइट. 10 टाइम्स ज़्यादा डेथ हुई है, करेक्ट. तो दिस इज कॉल्ड एज एक्सेस डेथ, राइट. आई होप यू आर गेटिंग माई पॉइंट. Excess deaths are calculated as the difference between the number of deaths that have occurred and the number that would be expected in the absence of the pandemic based on data from earlier years. जो normal years से उससे मैं compare करूँगा pandemic deaths से, तो जो difference आएगा उसको कहते हैं excess deaths. Excess mortality includes deaths associated with COVID-19 directly or indirectly, right, due to the pandemic's impact on the health system. अब कई ऐसा भी चीज़ें हैं कि क्योंकि पेंडेमिक के अंदर ऑक्सीजन सिलेंडर्स की बहुत ज़्यादा रिक्वायरमेंट हुई थी, वेंटिलेटर्स की बहुत रिक्वायरमेंट हुई थी, मैनी पेशेंट्स डाइड बिकॉज ऑफ द लैक ऑफ ऑक्सीजन सिलेंडर्स और बिकॉज ऑफ लैक ऑफ वेंटिलेटर, राइट. अब जो क्रिटिकली इल पेशेंट्स दूसरे भी होते हैं, जैसे जो हार्ट पेशेंट्स है या कोई एक्सीडेंटल डेथ है, उनको भी वेंटिलेटर की ज़रूरत थी, उनको भी ऑक्सीजन की ज़रूरत थी, बट दे वर नॉट एबल टू गेट द सेम बिकॉज इट वॉज बींग डाइवर्टेड टू द कोविड रिलेटेड हेल्थ इंफ्रास्ट्रक्चर. कोविड को टैकल रिजॉल्व करने के लिए डाइवर्ट हो गया था. इस वजह से जो नॉन कोविड रिलेटेड डेथ्स है वो भी हो गई इनडायरेक्टली कोविड की वजह से. वाई? बिकॉज द हेल्थ इंफ्रास्ट्रक्चर वॉज कंप्लीटली disturbed and the health facilities like ventilator and oxygen cylinders were diverted to tackle the COVID-19 problem, right? And that is also, and this is how many people also died, because directly not because of COVID but indirectly, right? So excess death के अंदर हमेशा ये चीज़ ध्यान रखिए कि this data always includes the COVID-19 related deaths directly or indirectly. Indirectly because due to the pandemic's impact on the health system, because excess death ये नहीं देखता है कि वो pandemic की वजह से हो रही है या दूसरा कोई उसका reason है, right? But the number of deaths is called as the count of the deaths is called as excess deaths, right? तो उसमें ये it was being found that after pandemic, the excess deaths were nearly 10 times, the government's official count, and it includes both the directly and the indirect deaths, right? So the government is already contesting this report, and let us see what will happen, right? So this is all about the news, right? The civil registration system जो कि the count of deaths register करता है वो उससे information लिए, and the Registrar General of India, right? So right, and the same article talks about from the Reuters, WHO, whose headquarters are there located in Geneva, Switzerland. So this article you can just read it through, right? So I hope it is clear, guys. I guess and I trust that it was an interesting session, and stay tuned for more such updates, right? And the lectures would be very informative and helpful to all the students preparing for the law exams, UPSC, SSC, and all other government examinations. Wish you all the best. Signing off. Good day. Goodbye.